everybody, Stephanie here with the Machine Gun Nest with our newest legal update. So we have so much to recap. We have so much that's happened in the world of the Second Amendment, so I'm going to start at the top and move our way through. So you may or may not have heard about the pistol brace ruling. If you don't know what a braced pistol is or why you should care about any of this, I have something here. I'm going to show you what a braced pistol even is. So right here we have an AR style pistol, and this is an SB tactical brace. A brace simply allows you to affix the pistol to your arm for more stability. Not all braced pistols look like this. It can look like a more traditional pistol, and there are many different types of braces, but it's just a way to help bring stabilization as you're shooting. So recently, the ATF said that if you have a braced pistol, it's no longer a pistol. It's called a short-barreled rifle. But what even is a short-barreled rifle? The government defines a short-barreled rifle with a barrel shorter than 16 inches, among some other qualifiers, but we're just going to keep it simple today. There's nothing inherently more dangerous about a firearm with a shorter barrel, but this was something that was made up back in the 1930s when the National Firearms Act was even created. We had Democrats in Congress who were rightfully upset about everything that was happening with Al Capone and all those other guys, but they came up with a term short-barreled rifle in order to try to regulate something. Obviously, we know that that was, it's ridiculous and meaningless, to say the least. So now the ATF, again acting not in good faith, has said that your pistols, if they're braced, they're now considered short-barreled rifles. And if you own one, you're automatically a felon overnight. But here's what they said. When the law hit the Federal Register, which it hit January 31st, we have 120 days to either file this via Form 1 in exchange for a free tax stamp, or we can swap and put a 16-inch or greater length barrel on it. You can remove the brace from it, or you can destroy the firearm completely or turn it into the ATF. So that puts a lot of us in this awkward position, and I'd like to talk to you about some inherent problems with what they have set up. Like always, the law, as in the rule that they have put forward, is very poorly written and leaves a lot of room for interpretation, and it doesn't actually cover all of the bases. So when you would be filling out a Form 1, you're filling out a Form 1 for something that's already constructed. Now, as the law currently sits and the rules according to the ATF are, you are not allowed to do that. You are not allowed to buy a machine gun, file for such a thing. You're not allowed to have possession of it. You can transact, but you are not allowed to take possession of this regulated item until you have your paperwork back from the ATF. So here, there is no provision in the ruling that would allow you to be in possession of it while you're waiting. And the way it currently sits also is after 88 days, if they don't get to your paperwork, it's formally denied. Now, right now, according to the current pace that the ATF has as far as processing this paperwork, if there are between 10 and 40 million braced pistols, and that's a rather conservative estimation, it would take about 20 years for the ATF to actually move through all of this paperwork. So it's a trap. Now, the third issue that others have found too is that many braced pistols would be a 922R violation, which has to do with firearms being imported. If the braced pistol was made overseas, it states that removing the brace does not cure the 922R violation. I don't see any reason why they would include such a thing. So if you are in possession of a foreign-made braced pistol, you're not allowed to Form 1 it. You're not allowed to remove the brace. You're not allowed to modify it in any way. It says that doing such does not cure the violation. I can't give you advice on what to do, and I would never ask somebody to intentionally violate the law. But honestly, as a gun owner here, this is a really difficult thing to do. I don't want to go to jail over a pistol brace, and I would never ask somebody else to do that either. But we are in a predicament here. This is clearly a mess, and I'm really hoping that some of the really great organizations out there like Firearms Policy Coalition, Gun Owners of America, take charge. If you can spare a few bucks, it does go a long way if you are willing to donate to these organizations to help get these things overturned. But primarily, the largest issue with this is not the outcome, it is the means to the outcome. So if you're watching this and you don't even like guns, maybe you're somebody that comes to my shop, maybe you come here and shoot, or maybe you live far away and you're just watching this YouTube channel to learn, which I love. The way they've gone about this is not okay. The ends do not justify the means if you're happy with the outcome here. What has happened is that the ATF has been allowed to effectively legislate the executive fiat. Instead of Congress, who we elect to represent us, saying, okay, we're going to change these laws, we're going to vote on it, we're going to debate on the floor to reflect the will of the American people. Instead, we have a law enforcement agency who's just changed a rule. And so even if you hate guns, you should not be okay with the way this has gone about. So even if you don't own a breech pistol, you don't care about any of these things, it's really important for the sake of our democracy and the way we function as a republic to make your voice heard regarding this. We're going to be posting a phone number below so you can call and contact your representatives and let them know that this isn't okay. Implore them to do something about it because, as they say, every phone call represents 10 angry people, and a whole lot of us are angry about this. So, moving on, we have had an incident in the state of Oklahoma. There was a gentleman who was on his way to work at a medical marijuana dispensary who had a loaded revolver in his car. Now, he was able to have a loaded revolver in his car. If you are permitted in your state to carry, you can obviously have a loaded firearm with you. He was pulled over, and a federal judge has ruled that just because you smoke marijuana or imbibe it in any way for medical reasons should not preclude you from owning a firearm. He said, the mere use of marijuana carries none of the characteristics that the nation's history and tradition of firearms regulation supports. So he's essentially saying just because you have a medical marijuana card shouldn't negate your God-given right to bear firearms. So as it sits now, no matter what state you're in, here in Maryland, you are allowed to have a medical marijuana card. You are allowed to have cannabis for medicinal reasons. Still on a 4473, there is a box, and if you check it, you are not allowed to own a firearm. So even if you live in a state where you are allowed to have marijuana, you're still federally not allowed to own a firearm. I'm interested to see how this is going to play out. My guess is that this isn't going to change until it elevates to the Supreme Court, until we have a ruling, because I don't want to be negative, but I don't necessarily see legislation coming forth to change this. But we're going to keep our eye on this story and keep you updated as it goes along. So next, let's pare down here and talk about what's going on here in Maryland. Now, last year, before the Bruen case, we kind of speculated that states would be implementing a lot of time and place restrictions, and we've seen that in New York, and now we're seeing that here in Maryland. And state Senator Waldstreicher, I don't know how to pronounce his name, Senators Waldstreicher and Senator Lee have proposed SB1, Senate Bill 1, which is essentially a massive place restriction on where you can carry your legal concealed carry firearm. I'd like to read to you some of these things. So in the beginning of the bill, it says it's for the purpose of prohibiting a person from knowingly wearing, carrying, transporting, blah, blah, blah. Again, knowingly is very difficult because you're starting to get into gray area. You're starting to get into intent there. It's not something you could ever win. It says it doesn't apply to somebody passing through. So it doesn't apply if you're carrying a firearm just passing through on a thoroughfare of an easement or such. And then on the third place of the bill, this is what's really alarming. This is where you would be prohibited. An inn, a hotel, a motel, or anywhere that provides lodging to transient guests. A restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or other facility principally engaged in selling food, alcoholic beverages, etc. for consumption. A motion picture house, theater, concert hall, sports arena, stadium, or other place. Listen to this. A retail establishment that is operated by a public or private entity. What isn't? Essentially every business, and offers goods, services, entertainment, recreation, or transportation. So there are others as well. There are other restrictions, but this is crazy. So if you're an establishment and it's owned either privately or publicly, you can't carry there. Now, I never want to say never because I just never want to, I never want to underestimate the crazies here in our state. I don't think this bill is going to pass in its current iteration. But as we know, when something is put forth, especially something restrictive like this, they're going to put forth the most crazy version of it possible in hopes of getting a lesser version of it passed. This is still in the works. This is still being debated. this doesn't need to pass in its current state. What we can do to ensure that a draconian bill like this wouldn't pass would be, you guessed it, make your voice heard. Speak up, email, call these people, call them all the time. Become the most annoying human being on earth to these people to let them know that this is not acceptable. Now, we know in light of the Bruin case from last year that this would not hold up in the Supreme Court, but they already know that as well. They're putting this bill in place to pat themselves on the back to say that they have done something to make the public safer. Now, what's going to happen is this: if this does pass in some lesser iteration, somebody would have to take this to court, maybe even elevate this to the Supreme Court, and that's when it would be kind of rescinded or overturned or shot down. But we don't even want to have to go through any time of waiting for that to happen. So please make your voice heard now. That's all we got today. We're going to keep you updated as these change, and I'll see you at the range.